Bill H.R. 6116, sponsored by Congresswoman Donna Christensen, passed the U.S. House of Representatives Wednesday and is on its way to the Senate.
In the opinion of the chair, 2/3 being in the affirmative, the rules are suspended, the bill is passed, and without objection, the motion to reconsider is laid on the table.
The legislation means decisions made by the VI Supreme Court will be reviewed directly by the U.S. Supreme Court instead of going through the Third Circuit Court of Appeals. Delegate Christensen testified before her colleagues Wednesday.
Today, the House will take the first step in making the Virgin Islands Supreme Court just like every other high court in the states and territories. This is just one more step on the journey for further local self-governance.
In June, the Third Circuit Court of Appeals Judicial Council presented a glowing 5-year performance review of the VI Supreme Court, and Christensen said it's a testament to the work they've done since 2007.
The Third Circuit report concluded that the U.S. Virgin Islands Supreme Court develops sufficient institutional traditions to justify direct review of its final decisions by the United States Supreme Court and urged Congress to enact legislation providing that the Supreme Court of the U.S. Virgin Islands enjoy the same relationship with the U.S. Supreme Court as the highest court of any state.
Passage of this legislation would put the VI Supreme Court on the same level as every other state high court.
H.R. 6116, sponsored by my good friend and gentlelady from the U.S. Virgin Islands, Dr. Christensen, simply puts into legislation the decision vetted by the Judicial Council of the Third Circuit, established through a process which has already been authorized by Congress.
Mr. Speaker, I ask members to support the bill, and I yield back the balance of my time.
Erica Parsons, News 2.